Now I am going to dictate a legal passage based on latest Supreme Court judgment at the rate of 120 words per minute. Let's start. The two appellants before us were implicated in FIR number 26 of 2005 registered under sections 143, 147, 148 and 302 read with 149 of the Indian Penal Code 1860 within bracket IPC by Bannerghatta Police Station, Bangalore Rural District. They were tried by the Learned Session Judge, Fast Track Court 2, Bangalore Rural District in Sessions Case number 232 of 2005 along with three other accused persons for offences under the aforesaid provisions and also section 120B IPC para. By judgment dated 03/05/2006, the trial court acquitted all five of them of all charges aggrieved. By their acquittal, the state of Karnataka preferred criminal appeal number 1544 of 2006 before the High Court by the impugned judgment dated 29/03/2011. A division bench of the High Court reversed the acquittal judgment passed by the trial court and held five accused guilty of offences punishable under sections 143, 147, 148, 120B and 302 read with 149 IPC para. Aggrieved thereby, all the five accused persons joined together in filing this appeal before this court. However, as they failed to surrender after their application for exemption from surrendering was rejected, the appeal stood dismissed in its entirety pursuant to the order dated 01/03/2012. Thereafter, upon the surrender of Ramesh Kumara and Parveen Alexander, appellant numbers 1, 2 and 5, the appeal was restored insofar as they were concerned para. The appeal was admitted on 28/03/2016 and at the time this court dismissed the appeal insofar as appellant numbers 3 and 4 were concerned, as they had not surrendered. Parveen Alexander, appellant number 5, expired thereafter, and taking note of the same by the order dated 01/04/2019, this court dismissed the appeal insofar as he was concerned on the ground of abatement in effect. Only appellant numbers 1 and 2 remain in the picture. They were granted bail by this court on 29/04/2019 para. The crucial aspect to be noted first and foremost is that the High Court has reversed a judgment of acquittal. The High Court was also conscious of this, as it was duly noted in paragraph 9 of the impugned judgment. The parameters for interference with an acquittal judgment being well defined, we would have to see whether the High Court was justified in doing so para. The case of the prosecution was that the five accused hatched a criminal conspiracy to murder Babu Reddy, the deceased, and attacked him with deadly weapons on 07/02/2005 at about 7:30 a.m. This attack was stated to have taken place near Hulla Holly Gate bus stand in Bangalore Rural District. The deceased was doing real estate business in partnership with M. Ramaiah within bracket PW1. Ramesh, appellant number 1, and his brother are stated to have approached the deceased for selling their land at measuring acres 2.06 guntas para. Thereupon, the deceased is said to have mediated the sale of this land to one Narayan Reddy within bracket PW10, and rupees 2,50,000 was allegedly given as advance to appellant number 1 and his family members by Narayan Reddy within bracket PW10. However, about 15 days prior to the death of the deceased, appellant number 1 is said to have approached him along with his mother and asked him to get the sale transaction cancelled by taking back the advance amount received by them para. The deceased supposedly told them to approach Narayan Reddy within bracket PW10 directly, as he was only a mediator. Appellant number 1 is stated to have abused the deceased, saying that he would teach him a lesson. This was the alleged motive for the criminal conspiracy and the consequential fatal attack upon the deceased parent. It is the case of the prosecution that on 07/02/2005 at about 7:30 a.m. the deceased was standing along with M. Ramaya, PW1. Stop. Thank you.